Hello viewers, welcome back to my channel. Today I will discuss with you what is bail and the cases when bail can be granted. So the students who are pursuing BA LLB or LLB and the people who wants to gain knowledge about the legal matters, this video will be helpful for them. And if you like my videos, then subscribe my channel and don't forget to let me know on which topics you want to get video. So without any further delay, let's start the video. Bail. When can be bail granted? Bail is derived from the French word baillier, which means to give or to deliver. The word bail has not been defined under the Code of Criminal Procedure, which was the previous code for deals with the criminal matters. But the Bharatiya Nagarik Suraksha Sanhita section 2b define bail. Bail is basically temporary release of an accused person or of a person who has been suspected of commission of an offence from the lawful custody upon such terms and conditions imposed by the officer or court of law on execution by such person bail or bail bond. According to Black's Law Dictionary, what is contended by bail is to procure the release of a person from where from the legal custody when by undertaking that he shall appear at the time and place designed and submit himself to the jurisdiction and judgment of the case. Now, why bail is given? Bail is given to prevent the unconvicted persons from suffering unnecessary imprisonment. Suppose a person has not committed an offense and he is given a imprisonment while the trial is ongoing, then it will be an injustice to punish that innocent person. To prevent this, bail is granted, and bail is granted in case of a bailable offense as a matter of right. Bail is a matter of right and jail is an exception. It also assures the reappearance of the accused or suspected person before the court of law when he is called upon. And when bail can be granted, in which cases it is discussed under section 436 of the Code of Criminal Procedure and section 478 of Bharatiya Nagarik Suraksha Sanhita. The section 436 clause 1 of the Code of Criminal Procedure states that a person who is accused of a bailable offense can be released on bail if the given conditions are fulfilled. He has been arrested and detained by the officer in charge of a police station, or he appears or brought before the court and the person is prepared at any time while he is in custody or at any stage while the proceedings is going on to give bail. Proviso 1 of subsection 1 gives a discretionary power to the officer or the court to give bail to an indigent person who is unable to furnish bail within 1 week from the date of his arrest without surety. Okay, section 436 clause 2 of the Code of Criminal Procedure states that when a person who is released out of bail and he abscond or failed to comply the conditions which is imposed on the bail bond as regards to the time and place of attendance, then the court can refuse to grant him bail. And when the person is brought before the court subsequently on the same case, then the court shall have also the power to order the surety to pay penalty under section 446. The important case law on this point is Aluka Sandro Orea versus State of Karnataka. It was held that giving bail is not a license to commit a number of offences. It was also held that the right to claim bail becomes circumscribed when the person is commit a number of bailable offense when he is out of bail.